They do not represent the views of the CFPB. Today's meeting will run from 11 a.m. and conclude at approximately 12:30 p.m. Eastern Time. As a reminder to CAB members, during today's meeting, if you would like to make a comment, please use the raise hand feature, mute and unmute button, and please remute when finished speaking. Also, please feel free to use your video. Members of the public will be attending in listen-only mode for the entirety of today's meeting. For introductions, I will start with our external guests, then CAB members, and then CFPB staff. Please state your full name and organization. I'll go ahead and start with Steve, please.
Sure. It's Steve Simpson, Pacific Legal Foundation.
Good morning. Jim Giudice, General Counsel and Chief Legal Officer, Public Square.
Good morning. David Herman, General Counsel, Cordova Financial.
And we can go over to our CAB members now.
Hi, good morning. My name is Kashana Hill with the Redress Movement based in New Orleans, Louisiana. Thank you.
And good morning. My name is Thomas Fitzpatrick. I'm at Housing Opportunities Made Equal of Virginia, based in Richmond, Virginia.
Thank you, Thomas and Cassandra. I can go ahead now. I am pleased to welcome Victoria Dorfman, Senior Advisor for opening remarks. Victoria, the floor is yours.
Thank you. I also would like to introduce Bobby Connor, who will be presenting with me. Thank you all for being here today. I'm pleased to welcome everyone to the newly configured Consumer Advisory Board as we fulfill our statutory mandate to seek counsel from outside experts on how Consumer Financial Protection Bureau can better serve the public as a responsible financial regulator. This morning's meeting is about fair lending. The CFPB was created to ensure that all consumers have access to markets for consumer financial products and services, and that markets and services are fair, transparent, and competitive. And the CFPB's fair lending efforts focus on ensuring fair, equitable, and non-discriminatory access to credit for both individuals and communities. However, the prior administration's regulatory overreach affected many businesses and has necessitated a course correction by this new administration. We have seen egregious examples of companies being targeted for protected political speech and exercising their constitutional rights. Today, we will review the previous administration's weaponization of its regulatory power that initiated politically motivated investigations and how the new administration has rectified these issues. We will then cover this administration's shifts in fair lending policy and our fair lending enforcement and supervision priorities, highlighting fair lending areas of focus such as debanking based on religion, political viewpoint, or other unlawful reason. And before closing, we will have a discussion on how the CFPB can work better with stakeholders and what fair lending issues you're seeing on the ground. So let's get started. We're joined by Steve Simpson, Director of Separation of Powers Litigation at Pacific Legal Foundation. Steve represented Townstone Financial in a case of CFPB versus Townstone and Barry Storner, a case CFPB filed in the U.S. District Court for the Northern District of Illinois. The Bureau filed this lawsuit in July 2020 against Townstone, which is non-bank retail mortgage creditor and broker based in Chicago, Illinois, and CFPB alleged violations under the Equal Credit Opportunity Act, its implementing regulation Reg B, and Consumer Financial Protection Act 2010. CFPB's current leadership believes this fair lending case is a prime example of the prior administration's weaponization of the Bureau, using a redlining screen based on an arbitrary number of mortgages. CFPB went after the small Midwestern firm with about 10 employees and a radio program. So thank you so much, Steve, for being here today and taking time to join us. Although this matter has received some attention in the press, can you take us back to the beginning and give us a quick summary of what happened to your client, Townstone?
Sure. And first, let me say thank you, Victoria, and thanks to the CFPB and the administration for having me here to talk about this very important case. So I'll just very quickly summarize the way I think about this case is that it was entirely based on statistics and free speech. And there was never really any evidence of discrimination at all. Just to give you the really short summary, in about 2017 or 2018, CFPB identified Townstone as a kind of target for investigation based on an alleged shortfall of minority applicants relative to other peer lenders in Chicago. In the course of its investigation, it identified a handful of comments that Townstone made on a weekly radio show. I can elaborate on this in a moment. That, in essence, CFPB found offensive, and on that basis, put Townstone through a 7-year ordeal involving a 3-year investigation, a 5-year lawsuit. Ultimately, Townstone had to settle based on just the weight of the and the burden of the litigation. And through it all, CFPB never identified any evidence of actual discrimination. So that's sort of the short summary, and I'm more than happy to elaborate on any aspect.
So in your opinion, what went wrong if the CFPB wasn't preventing discrimination? What was it doing?
Yeah, I think that the evidence demonstrates, and this is both based, this was kind of a hunch that I had during the lawsuit. Of course, we weren't seeing everything from inside CFPB's files, but afterwards, all of you at CFPB conducted an investigation, and more evidence was revealed. The way I would put it is the Bureau singled out Townstone because it was, I think, a convenient target to make an example of. And I think the evidence shows that pretty clearly, and I can just kind of run through a handful of things. So it all started off with what was referred to, what you referred to, and internal at CFPB referred to as a redlining screen, which I gather was sort of an audit of a bunch of mortgage companies across the country, I think thousands of them. And based on different parameters, they narrowed down their target. And essentially what it looked like the CFPB was looking for was mortgage companies that loaned to too few minority applicants relative to other mortgage companies. The way I thought about this during the lawsuit was essentially they were targeting Townstone because it was below average. And the question I always asked is it a crime or is it a violation to be below average, to be less than other people? That can't be right, because somebody is always going to be below average. And it never made any sense to me. After they identified Townstone, that when they discovered that Townstone had a weekly radio show, so since about 2014, 2015, a prior loan officer that worked at Townstone launched it was sort of a talk radio show. The idea was advice, discuss mortgages, have call-ins, and maybe we can drum up business through that. Later on, it became a podcast, which, to be frank, and this comes from the president of the organization, my client, Barry Sterner, he said, I think the only people who ever listened to that podcast were my mom and my sister. And the main reason they listened to it was so they could criticize me afterwards and say, what the heck are you doing? This is boring. But in any event, so when CFPB found the radio show, they used audio mining software to scour all 79 hours of content. This is 79 hours over a roughly 5-year period. So it was a half-hour podcast. It was a 1-hour radio show. It didn't run continuously every week. But anyway, they had 79, 80 hours of content. They scoured it with audio mining software. So, and I gather what they did based on the way they did discovery was look for terms that I think CFPB might find offensive, or terms that would indicate discrimination. They identified 5 comments on the show over a roughly 5-year period that CFPB believed were disconcerting and offensive comments. We reject all that, but I can give some examples of the comments. After that, CFPB lawyers conducted an 8-hour interview on the record, basically a deposition of my client, Barry Sterner. They pulled the old lawyer trick, which is you wait until 4 o'clock in the afternoon when the witness is tired. They then presented him with these radio show comments. He had no idea this was coming. He thought this was just a big misunderstanding, and if he just sat down and talked to CFPB, he could work it out and the investigation would go away and move on. They pressed him and said, don't you think these would be offensive or discouraging to people? He said, look, I didn't mean to offend anybody. I'm sorry if I did. It was that kind of situation. They used that as a basis to claim, oh, he admits that these violated the law. He never did. And then, despite never having any evidence, not only no evidence of any discrimination, no evidence of anybody ever complaining about discrimination, they didn't even have evidence of anybody who heard the radio show comments, the allegedly offensive comments, and complained about that. So as far as we know, no one ever even heard any of these comments. And anyway, that's the sort of gist of the problem is no evidence and looking for really, I think, a scapegoat, given the times and the a lot of the public debates about race and other issues. I think they were just looking for a target.
Can you tell us more about the comments made by
Yeah.
Brownstone and freedom of speech issues that are implicated?
Sure. So sorry. So I think the easiest way to understand the nature of the show and is just to go to what CFPB itself thought. And the way we discovered this after the internal investigation that you all conducted, the way CFPB, I gather the lawyers or the bureaucrats at CFPB described the Townstone show was overtly political and often critical of the Bureau. Anybody who knows anything about free speech laws knows that overtly political speech is the speech that gets the highest protection under the First Amendment. And of course, it is absolutely within the bounds of everybody's right to free speech to criticize the Bureau. I don't think Barry Sterner criticized the Bureau all that much. I think he poked fun at them every once in a while, but they talked about a lot of things. And in any event, so just to back up a little, that gives you kind of a flavor of the show. It was sort of an experiment. They wanted to do this talk radio to see if they could drum up business. I'm not sure if it ever really did result in any business, but the kind of things they did was they talked about mortgage financing, they talked about home buying, they talked about real estate investing. They took callers, and then when they got bored, they talked about all kinds of other things. Sports, they talked about crime in Chicago, they talked about life in Chicago, the kinds of things that people who live in Chicago would talk about. And so the nature of the comments were basically a handful of times, and I should also point out that I don't think I pointed this out before, but out of the 79 hours of radio show content, CFPB identified 16 minutes in which these comments fell. So that's 0.33% of the overall time over, and we're talking about a 5-year period. So crime was a big deal in Chicago. On a few occasions, Mr. Sterner said things like, if it weren't for the police in Chicago, I really think this town would become, or the South Side would become, a war zone. And one other occasion, they were talking about one of the loan officers on the show said he had gone skydiving. And one of the other guys piped up and said, why do you need to go skydiving? That's dangerous. Just run through the South Side and you'll get a thrill. That kind of thing. This is what people in cities talk about. And these are the nature of the comments that CFPB found, quote, disconcerting and potentially offensive to some listeners. And as I've said before, offensive speech, political speech, speech that lawyers in the government or regulatory agencies think is disconcerting cannot be the basis of a lawsuit. And yet, as I said before, there was never evidence that anybody even complained about these comments, much less heard them. And the only other evidence that CFPB had was purely statistical. It described it internally as circumstantial evidence, but it was crystal clear that what motivated this lawsuit was the speech.
So let me just ask you this. My recollection in working on this case that there was actually survey paid by Townstone to check with potential customers, consumers listening, and what was the conclusion of that survey? So
Townstone, when they finally understood what the case was about, they went out and they spent, I think it was upwards of $50,000 to do, and that's just for the survey. They did actually a consumer research firm did focus groups, and they set up a bunch of focus groups on different occasions with real consumers, people who identified themselves as interested in mortgages, real consumers in Chicago, a mix of minorities, white people, but a lot of African Americans in these groups. And they read the comments to them, and they talked about, what people's reactions were to comments in the radio show. They listened to excerpts and that kind of thing. Nobody thought there was anything offensive. In fact, a number of participants actually asked for Townstone's contact information because they thought these guys actually know what they're doing. Maybe I should check in with them about getting a loan. So nobody took offense at these. And then, sorry, I don't know if you followed, but I can say a few other things about
sure.
Sure. So, and And I mean, on top of this consumer survey, during both the investigation and the lawsuit, Townstone twice produced over 100 gigabytes of information. It was basically everything that Townstone had in its files, downloaded to CFPB. CFPB never identified one piece of evidence of discrimination, nothing at all. We did the same thing in the lawsuit again, and we went through and searched for any sort of offensive term from the emails, from any communications, anything that might indicate discrimination. There was never any evidence of that. We asked CFPB repeatedly during the lawsuit, identify anybody who was offended, anybody who thinks they were discriminated against. No evidence of that whatsoever. So despite no evidence, and a case that was unquestionably, I think you just can tell this if you just read the complaint, but when we saw the internal files, unquestionably motivated by the political and social views of my clients, and the conclusion that what they said was offensive, that was the nature of a 7-year battle that essentially put Townstone out of business and almost ruined Barry Sterner's life.
My understanding is the CFPB actually told Townstone early in the lawsuit that it believed it could seek $40 million in damages.
Yeah, its opening kind of offer of settlement. This is pretty typical in lawsuits. Is for I think regulatory agencies to try to settle the case. They went to Townstone. They said, based on our calculation, the number of comments you made and the number of days, several $1,000s per day, we could easily hit you with $40 million in fines. So that's what Mr. Sterner and Townstone were facing. Okay, I have a lawsuit. It's potentially $40 million. CFPB offered to settle for $1 million. Mr. Sterner felt very strongly that he hadn't done anything wrong. He ultimately came to PLF, and we took over his case, and he was able to litigate the case. But in 2024, just before the election, he felt, after having undergone what was an 8-year ordeal, settling made the most sense.
And he settled for $100,000.
Yes, 100,000.
So shortly after this administration took over the CFPB, one of the first items of business was to correct this absolutely flagrant misuse of government resources in Townstone. And so in March 2025, Acting Director Board sought to vacate the settlement the CFPB extracted from Townstone following the saga. The court ultimately declined to vacate the consent order, but this leadership firmly believes it was essential to expose the processes leading to this overreach. And so, together with our memorandum in support of our motion, we also filed an affidavit explaining what were the internal processes and how they have gone completely over the rails to basically abuse Townstone and to infringe on First Amendment rights. So we very much thank you for working on that case. And is there anything else you want to say about Townstone's experience?
I'll just say that I think Townstone always felt, and my sense reading articles about CFPB and many former attorneys and others who worked at CFPB, is that there's often, and I think this is true in regulatory agencies, the sense that regulatory agencies are at war with the regulated industries. I think this is all wrong and the wrong view, and I hope that can change. I really think regulatory agencies need to look at themselves more as, we could use the term traffic cop, but Townstone felt they were being attacked the whole time for no good reason. And of course, the only other thing I'll say is anytime government is going after somebody because of comments that they made on a radio show that the government agents or agencies think are offensive, that should be a red flag, a time to maybe check your premises and decide what the real reasons are for the investigation and suit.
Well, again, thank you so much for being here. We greatly appreciate you sharing it. We believe it's important to tell Townstone's story, and your presence today further helps right this wrong and raise awareness
Thank you.
of these issues. So now turning to our other guest speakers, Jim and Dave. For more than 4 years, Credova stood firm against the politically motivated investigation undertaken by the CFPB. In August, this leadership ended its investigation. After reviewing the case, we determined that the investigation exemplifies also the type of weaponization against disfavored industries and individuals that President Trump and Acting Director Board are committed to ending. Thank you, Jim and Dave, for joining us today to talk about Credova's experience with the CFPB. To begin our discussion, can you also give a brief summary? Was it similar to Talonstone in some ways?
Absolutely. First and foremost, Victoria and members of the CAB and leadership at the CFPB, thank you very much for having us. It's very special for us to be here, and we're excited for that. To begin, I want to provide a little bit of historical context so that folks can see how the Credova's experience with the CFPB is really related to the Second Amendment commerce in the firearms industry. So, going back into the 1990s, the firearm industry, for political and ideological reasons, has been a constant target of folks that are anti-gun. And in the 1990s, we really saw direct attacks against the industry. You saw state-sponsored lawsuits against firearm manufacturers and dealers for criminal misuse of firearms. Then in the early 2000s, the PLCAA was passed, which prohibited these types of malicious lawsuits. And then what we started to see was political and government actors kind of taking a secondary approach here and really attacking through cutting off or ostracizing the firearm industry from banking or financial services. And that's really where Credova comes in. So Credova is a point-of-sale financial technology company that offers consumer financing, tailored for the firearm and outdoor recreation space. Credova had to innovate in order to be able to provide these essential services to this industry that otherwise didn't have any service provider available to them. This made us also then a right target for some of these politically and ideologically motivated activities. So with that, I want to turn it over to Dave and kind of speak a little bit through the timeline of the investigation.
Absolutely. And thank you, CAB members, leadership of the CFPB, Victoria, Steve. These are all important stories to be telling. And where I'll start is this investigation didn't begin with Credova. It began with an investigation into a third-party service provider that Credova ultimately ended up using. When the Bureau leadership found that it was working with Credova, the investigation shifted. And when they learned about Credova's business and what industry it was supporting, we became the focus of the investigation. That investigation began in February of 2021. As I did when I was outside counsel for Credova, along with several other members, we met with the Bureau enforcement attorneys and we asked them, what is it that we're doing wrong? What is it that we need to be doing better? And they never could provide a clear and concise answer to that. In fact, it shifted many times over the course of the investigation as we continued to provide them evidence of our compliance with applicable federal law, state law, rules and regulations promulgated. Every time we would knock something down, they would come back with something else. And it became clear to us throughout the course of the investigation, not only through timing of certain events, but the shifting positions taken by the Bureau enforcement attorneys, that this was less about protecting consumers and more about shutting down lawful commerce in a disfavored industry. Again, this is a tactic that over my course as an attorney, I've worked with many of the government agencies, state AGs on enforcement actions, and this one felt very different from the perspective of there wasn't ever a clear violation of law that we could identify that was commensurate with the magnitude of the weight of the government that was coming down on Credova at the time.
So from your perspective, was this a typical engagement with the financial regulator if this happened?
Absolutely not. I mean, I have, over my career, worked on cases with DOJ, with the CFPB and FTC, the whole alphabet soup of government. And this was just fundamentally different. Again, what we saw was an investigation that began in February 2021. It was connected at first, with the New York Attorney General's office, which was very strange to us. Even the New York Attorney General's office trying to use CFPB subpoenas and process for them to conduct investigations of Credova, notwithstanding the fact that Credova does no business, has no customers in New York State. There's no nexus with New York State. So it was very concerning from my perspective and the attorneys I was working with, because that sort of misuse of process was something that was very strange and unusual to us, but also was being misused by both the Bureau and the New York AG's office.
And David, I think you make a really good point there, talking about misuse or abuse of process. Very often in these situations, it can feel like the process itself is weaponized and used as punishment. Folks got to understand, in the private sector, we have a bottom line, right? We have employees that rely on their paychecks, and they rely on us to build and grow a successful business so they can provide for our families. This is a multi-year investigation that was not focused on consumer harm, that resulted in hundreds of thousands of dollars of legal spend. And to Dave's point, the process itself was very unusual, particularly with the involvement of the New York Attorney General's office, and does not seem to me to be the type of process that a regulator would typically follow with a business that is seeking to comply with the industry requirements.
Before we get to the Second Amendment issues, let me ask some follow-up questions about New York Attorney General. So, as you said, it sounds like Credova did not have any business in New York. Why was New York Attorney General involved, and what was its purported role?
So I'll be happy to respond to that. I think the New York Attorney General's office simply did not like the business that Credova was in. It did not enjoy that we were bringing innovative financing options to consumers for use in the Second Amendment activity. And so, again, notwithstanding the fact that Credova did no business in New York City or in New York State, did no business with New York consumers, the New York AG's office continually seemed to lead the investigation, even in violation of the Bureau's own internal policies. New York Attorney General Office attorneys were trying to take depositions under a CFPB subpoena. And that was something that we had never heard of. When we brought up this fact and the fact that it violated CFPB published policies, the CFPB then changed tactics and said, well, we'll take the deposition. But throughout that deposition, it seemed as if New York Attorney General Office attorneys were feeding questions to the CFPB enforcement attorneys. They were the ones who were producing the exhibits to us. And when we ended the deposition, it was New York Attorney General Office attorneys in conjunction with the CFPB enforcement attorneys who were leading discussions about what they thought we did wrong, in terms of they simply did not like the fact that we were offering financing for firearms. Not that we were violating a law or a rule or a regulation. They simply did not like our products.
That seems very reminiscent of conduct that the Supreme Court unanimously condemned in NRA versus Buell, where New York Attorney General again went after the firearms.
Right, and Victoria, it's even deeper than that. Just like in the NRA v. Buell, what happened here was during settlement discussions, when the Bureau came in and was trying to force a settlement before the change of administration, after years and months of silence, they went to our third-party service provider and said, New York Attorney General's office said, settle with us for a minimal amount, and what we will do is you can agree to injunctive relief to cut off Credova from your services. And that would have left Credova in a position where it could not operate at all. And so if Credova would have been forced to come to the table at its knees, rather than identifying any process or rule or regulation, it was all about shutting us down.
That's
Yeah.
absolutely shameful.
Yeah, Dave, I think you're hitting on a really key point here in terms of the nature of this investigation. If it was focused on redress for consumer harm, you'd expect the injunctive and potential monetary relief to be along those lines. What we saw was not that. What we saw was injunctive relief being demanded that was specifically designed to put Credova out of business. It had nothing to do with redress for consumers. It had to do with creating a system where Credova had an inability to operate, and that no other regulated member in the industry was required to adhere to these standards. Because specifically, we would literally ask, we'd say, okay, well, what does right look like? Please show us examples. Please point to the regs. Please show us examples of folks that are required to do this in the industry. We were told that examples would be forthcoming, and they never came because they didn't exist.
So it sounds like it was pretty clearly an attempt to restrict lawful Second Amendment activity. Did CFPB make any commentary on this issue directly?
Well, they did. And again, during discussions with enforcement attorneys, both at the CFPB and with the New York Attorney General's office, they said they simply did not believe we should be able to offer this type of financing to consumers. And in fact, that was reflected in the draft consent order that they circulated to us, where they were asking for disclosures, as Jim noted, that are not required under Regulation M or the Consumer Leasing Act or Reg Z and TILA. What they were asking for was something that was being imposed on no other industry member, and that would have required Cordova to be at such a competitive disadvantage that we could not effectively compete in the marketplace.
My understanding is, in addition to suppressing lawful Second Amendment activity, there was an overlay of politically motivated pressure that happened here. Can you tell us more about that?
Yeah, I think a lot of this is really demonstrated in the timing of a lot of the Bureau's actions. So, as Dave has spoken to, what you would see is flurries of activity followed by months and sometimes more than a year of complete silence. And then oddly timed with public announcements related to Cordova and then, Public Square, Cordova's parent company, all of a sudden there'd be a renewed motivation to come and start requesting information, having conversations with us. So a good example of that is we had our NORA call with the Bureau in the fall of 2022. We provided our response. We did not hear from them for more than a year after that. The next time we heard from them was when Public Square announced publicly its partnership with Cordova in January of 2024. All of a sudden, there was more requests, additional requests for information and diligence. And then, of course, ultimately, when Public Square acquired Cordova, again, ramps back up, starts asking us questions. Another long period, months-long silence. As the election was upcoming in November, Bureau starts asking us questions again, requesting information. We answer, we help them out, we ask for examples are forthcoming, they're never provided. Election comes and goes. And then when Donald Trump Jr. was appointed to the board of directors of Public Square, again, Cordova's parent company, that very day, the announcement came out, I believe, around 8:30 or 9 o'clock in the morning. That very day, attorneys at the Bureau reached out to our outside counsel, demanded an emergency meeting. It had to be today. Again, this is after months of silence and after being told that they were going to show us exactly what they wanted, had to have the meeting that day. And then they provided us with a draft consent decree that was riddled with factual and legal inaccuracies, which we made them aware of. And we were presented and said, we need to get this settled prior to the inauguration of the new administration. Otherwise, we're likely to sue. And if that doesn't very clearly illustrate an ideological or political motivation by a federal regulatory agency, I don't know what does.
Thank you for sharing that experience. We have looked at all these internal documents, of course, and your impressions are completely correct. They were slightly done, politically motivated, and had no basis in the law. So is there anything else that you'd like to say about your experience with the CFPB under the prior administration?
Absolutely. And again, I want to thank everybody for listening to this story. It's a story that is maybe not unique with this agency. I've been representing consumers or companies in the consumer protection sphere for over a decade prior to coming to Cordova. And this investigation was just very, very strange from our perspective, even amongst other CFPB investigations. It was one that was very clearly not grounded in the law. It was very clearly grounded in politics. It was grounded in ideologies. And that's something that shouldn't ever happen, in my opinion, in this world. If what we were doing was wrong, and again, I don't think that Cordova has done anything wrong in terms of the regulations and the rules and the laws that apply to everybody, then it shouldn't have mattered what political party we ascribed to. It shouldn't have mattered what we were doing. It should have been, you violated the law, but we never heard what law we violated. We never heard what we did. And the problem with that is, from my perspective, that opens us up to regulation by enforcement. And companies have no clue how to comply with regulation by enforcement. It's essentially you show up, the CFPB tells you, we're going to extract a penalty from you unless you do something. And then we have to accept it, or else we face the weight of the full weight of the federal government. And that's something that Cordova held strong against, but it was very damaging to the company.
Yeah, and Dave, I mean, you hit the nail on the head. The last two things that I would say is like, look, this is all kind of about good governance, right? You know, what type of behavior would you expect from a regulator, and what type of behavior would you expect from a member of the regulated industry? And if there's a business operating in the industry that is working very hard to identify the applicable laws and regulations, understand them, apply them, constantly monitor and ensure that the business is adhering to them, and then they have an interaction with the federal regulator and they say, look, this is what the regs say, this is what we're doing, this is what everybody else in the industry is doing. Please tell us how we're not complying with the regulations. That should be model behavior, right? And instead, what we end up with is a very adversarial relationship between regulator and regulated business. And that is not good governance for businesses and not good governance for the American people. The second thing that I'll close with here that's very important is understanding our experience and context. Again, the firearm industry and the Second Amendment has been under a constant attack for decades. It began as a direct attack that was thwarted by some very good legislation in the early 2000s, and then it has turned into indirect attack. Now, we have dealt with this as a financial technology company where we are being punished for our support of the firearm industry, and we have just a slew of stories of industry members, retailers, and manufacturers that have been directly targeted either through debanking or again being cut off from financial services. And that's really what's core to this story. And that is there is an industry that doesn't just sell products. It sells products that are constitutionally protected, that needs access to financial services and banking services so that it can sell those products. And businesses like ours that have been very intentional about supporting the individual right to bear arms, the Second Amendment and the firearm industry have been targeted by regulators both at the federal and state level that make it very, very difficult for a business to survive and operate.
Well, I salute Cordova and you for standing firm, for not giving into pressure. And as you know, we've closed the investigation. We provided the CAB members with our letter outlining the many problems that have occurred in the course of investigation. And we thank you for being here and about these issues. This is absolutely not the way CFPB should function, and we are doing everything we can to curb those abuses.
And we thank you.
Thank you.
So please bring up slide 3, CFPB transition. So now that we have discussed the weaponization of the CFPB, it's time to close the chapter in Bureau's history and talk about the CFPB's present and future. We're very pleased to update you on the CFPB's new direction, highlighting our fair lending work since the new leadership took over. Over the past several months, due to the transition leadership, we have undertaken an extensive review of the operations. And during that time, we have made changes consistent with this administration's and this Bureau's leadership policies and priorities. Acting Director Ward has stated that he's committed to implementing the President's policies. And so we have been busy implementing several executive orders impacting our fair lending work, including, as you see on the slides, Executive Order 14281, Restoring Equality of Opportunity and Meritocracy, which directs federal agencies to stop using disparate impact liability in their enforcement of civil rights laws. The second order is 14173, Ending Legal Discrimination and Restoring Merit-Based Opportunity. It requires all executive departments and agencies to terminate all discriminatory and illegal preferences, mandates, policies, programs, activities, etc. And it further requires agencies to enforce civil rights laws and combat illegal private sector diversity, equity, and inclusion preferences, mandates, policies, programs, and activities. Finally, Executive Order 14331, Guaranteeing Fair Banking to All Americans, which seeks to address debanking so that no American is denied access to financial services because of their political or religious beliefs, and states that banking decisions must be made on the basis of individualized, objective, and risk-based analysis. Of course, all these orders address the overreaches that we have heard about under prior administration. So next slide, please. So to comply with these executive orders and the new administration's priorities, CFPB leadership has made significant shifts in our fair lending work. Consistent with Executive Order 14281 concerning disparate impact, the CFPB will no longer use disparate impact in its supervision or enforcement of fair lending laws. To that end, we have closed all elements of multiple open exams and investigations that relied on disparate impact liability. We also terminated CFPB orders that relied on disparate impact liability, including administrative order against Synchrony Bank. Similarly, the CFPB is focusing its supervisory and enforcement resources on fair lending matters with direct evidence of overt racial discrimination and identifiable victims. Consistent with this, on May 15th of this year, the Bureau issued a no-action letter for its order in the District Court for the Northern District of Illinois against Draper and Kramer Mortgage Company Corporation, which was based on claims of redlining. Under the no-action letter, the CFPB ceased monitoring compliance with the order, will not engage in any supervisory activity to assess compliance with it, and will take no further steps to enforce the order. Also, the CFPB, in coordination with the Department of Justice, successfully terminated several orders, such as against Trustmark National Bank and Trident Mortgage Company. One was in the District Court for Western District of Tennessee, the other in the Eastern District of Pennsylvania. And both of those involved claims of redlining, and we terminated them in May and June. The CFPB also terminated its administrative order against Bank of America in June. The order was based in part on findings that loan officers were not asking applicants for required demographic data. The next issue is special purpose credit programs. The CFPB will also no longer be consulting with institutions regarding any special purpose credit programs, SPCPs, that rely on race, national origin, or sex, and that is in compliance with Executive Order 14173, which obligates all executive departments and agencies to terminate all discriminatory and illegal preferences and to combat illegal private sector race and sex conscious programs. Consistent with this executive order and recognizing the broader statutory and constitutional concerns raised by such programs, the Bureau has proposed a rule that would prohibit creditors from offering programs that rely on the race, national origin, or sex of the applicant in making credit decisions. In the meantime, the Bureau reserves the right to continue enforcing fair lending laws against unlawful discrimination based on national origin, race, and sex. And now I will turn it over to Bobby Connor from the Office of Fair Lending to discuss the Bureau's efforts to address debanking and our supervision and enforcement.
Thank you, Victoria. Debanking is one of the CFPB's main priorities. As such, CFPB leadership has dedicated resources across the Bureau to implement the President's executive order on debanking. The President's executive order directs federal banking regulators, in part, to review their guidance and regulation for reputation risk or equivalent concepts that could result in politicized or unlawful debanking. The executive order also directs regulators to identify financial institutions that have engaged in unlawful or politicized debanking and take appropriate remedial action. Consistent with this executive order, the CFPB reviewed its examination manual and confirmed that it does not reference reputation risk. We are also reviewing our guidance, regulations, and other materials used to regulate or examine entities under our authority, and we will make changes as appropriate to any materials that include reputation risk concepts that could result in unlawful debanking. The CFPB is also currently reviewing consumer complaints as well as supervisory and enforcement data for evidence of potential debanking. Going forward in the debanking context, the CFPB will be evaluating financial institutions for compliance with the Equal Credit Opportunity Act, or ECOA, and the Fair Credit Reporting Act, or FCRA, and in particular, the adverse action notice requirements under those laws. We are also working with other regulatory partners, including the DOJ, as part of the DOJ's debanking task force, to address debanking issues more broadly. Financial institutions should consider reviewing current and past policies and practices, including underwriting and eligibility criteria, account processes, and complaints to assess debanking risk associated with the executive order and with existing federal and state laws. Next slide, please. With regard to our supervision and enforcement priorities, the CFPB is only focusing on areas clearly within our statutory authority, and we are prioritizing pressing threats to consumers. We are focusing on actual fraud against consumers where there are identifiable victims with material and measurable consumer damages, and redressing tangible harm by getting money back directly to consumers. Next slide, please. With regard to fair lending, matters with direct evidence of intentional racial discrimination and identified victims shall be brought to the leadership's attention and maximum penalties will be sought. Fair lending supervisory activities will focus on entities' compliance with ECOA and HMDA. ECOA examination work will focus on uncovering direct evidence of intentional discrimination on a prohibited basis, systemic failures to provide applicants with legally required notices of adverse actions, and lender systems for identifying risks of noncompliance with ECOA and its implementing regulation, Regulation B. HMDA examination work will focus on validating the accuracy of key data points collected and submitted by lenders. As I previously noted, we are reviewing our consumer complaints and supervisory and enforcement data for evidence of potential debanking. Additional fair lending supervisory work may be scheduled to follow up on potential debanking findings identified from our review. Back to you, Victoria.
Next slide, please. The CFPB has a strong focus on protecting and providing redress to service members and their families and veterans, as we outlined in our priorities memo back from April. And I'd like to talk about a couple of cases that are directly relevant to this. First Cash is the first one. Consistent with this priority, the CFPB and First Cash, along with its 19 subsidiaries, resolved the Bureau's lawsuit that was started in 2021. The lawsuit alleged violations of the Military Lending Act, MLA. The party reached a settlement and jointly filed the stipulated final judgment and proposed order, which the court promptly entered the same day. The MLA provides protections for active duty service members and social dependents in connection with extensions of consumer credit. And these protections include a maximum allowable annual percentage rate of 36%, a prohibition against required arbitration, and certain mandatory loan disclosures. Specifically, the CFPB alleged that since October 2016, the defendants violated the MLA by making pawn loans, which are small loans secured by personal property, to covered borrowers with rates that exceeded the Act's maximum allowable annual percentage rate of 36%. The CFPB also alleged that the loan agreements with covered borrowers violated the Military Lending Act by requiring arbitration in the case of dispute and by failing to make required disclosures. The order requires the defendants to set aside $5 million to ensure full redress armed service members and their family members in connection with thousands of unlawful pawn loans, pay $4 million fine to the CFPB Victims Relief Fund, and to comply with the Military Lending Act by either offering an MLA-compliant loan product to service members and their families, or complying with the regulatory safe harbor meant to screen for MLA-protected borrowers. And here I'd like to talk for a second about the MLA-compliant loan product. This is something that CFPB came up together with First Cash to ensure that it can continue doing its business and in conjunction with the realities faced by service members and their needs. So this was an example of how the new CFPB tried to work with the business instead of against a business, and to respect what it was trying to do and to actually ensure that consumers are able to get the product that they would like to get. The second case is MoneyLion Technologies. The CFPB settled another MLA matter recently on September 29th, 2022, the Bureau filed a lawsuit against MoneyWine Technologies and 37 lending subsidiaries. MoneyWine is a fintech company, formerly known as MoneyWine Inc., that offers online installment loans and other products to consumers through its lending subsidiaries and membership programs through its subsidiary ML Plus. The MOA contains a number of protections for active duty service members and their dependents, which, as we discussed, are covered borrowers. So the CFPB alleged that MoneyWine and its lending subsidiaries violated the MOA because they charged covered borrowers annual percentage rate in excess of 6% and did not make all the required disclosures. The CFPB also alleged that MoneyWine and MoneyWine Plus violated Consumer Financial Protection Act 2010 by misrepresenting that covered borrowers owed loan payments and associated fees when they did not, because loan contracts were void, and by not permitting consumers with unpaid loan balances to exit membership program. And finally, continued to charge and collect monthly membership fees after consumers had asked to cancel their membership or terminate ACH fee withdrawals. Again, we worked together with the company to come up with a solution that allows them to continue offering a product that is MOA compliant. And so on November 21st, 2025, the CFPB and all defendants jointly filed a proposed stipulated final judgment and order to resolve the Bureau's claims. That was Friday, and the court entered it, I believe, on Monday, November 24th, 2025. The stipulated final judgment and order, among other things, required the defendants to pay $1.75 million in consumer redress and to ensure that their products comply with the MOA. I will turn it back over to Bobby to discuss the Bureau's rulemaking concerning fair lending.
Thank you, Victoria. The CFPB is undertaking several priority rulemakings. With regard to fair lending, in June and October of this year, the Bureau extended the compliance deadlines for the small business lending rule under Section 1071 of the Dodd-Frank Act by approximately 1 year. We are also deprioritizing the enforcement of this rule. More recently, in November, the CFPB issued a proposed rule for public comment to amend the small business lending rule. The proposed rule notably proposes 2 changes to the covered financial institution definition. 1, to exclude farm credit system lenders from coverage, and 2, to raise the origination threshold from 100 to 1,000 covered credit transactions for each of 2 consecutive years. The proposed rule also makes conforming changes to the bona fide error portions of the enforcement provisions of the rule. The proposed rule would also change the gross annual revenue threshold in the rule's definition of small business from $5 million or less to $1 million or less. The proposed rule would also remove the discretionary data points for application method, application recipient, denial reasons, pricing information, and number of workers. It would also modify the collection of data concerning business ownership status of small business applicants and the formatted demographic data collected concerning the principal owners to comply with an executive branch mandate. These proposed changes generally include 1, removing references to and questions about LGBTQI+ owned business status. 2, requiring financial institutions to inquire about the principal owner's sex rather than sex gender. And 3, providing that the sex of the principal owners be selected from a static binary response option of male or female, rather than a free-form text field. The proposed rule would also change the provisions on the time and manner of data collection to remove various prohibitions on discouragement. It also adds a provision that would emphasize for applicants their statutory rights under the rule. Finally, the proposed rule would extend the rule's compliance date to January 1st, 2028 for all financial institutions covered by the rule. The public comment period for this proposed rule closes in 5 days on Monday, December 15th, and we encourage all interested stakeholders to submit their comments by the deadline. In November, the Bureau also published a proposed rule for public comment to amend Regulation B, Subpart A, the regulation implementing ECOA. I just want to highlight a few significant changes proposed for Regulation B. Consistent with the President's Executive Orders 14173 and 14281 that Victoria discussed earlier, the proposed rule provides that ECOA does not authorize disparate impact claims. And it would amend the prohibition on discouraging applicants or prospective applicants to clarify that, one, it prohibits statements of intent to discriminate in violation of ECOA and is not triggered merely by negative consumer impressions. And two, encouraging statements by creditors directed at one group of consumers is not prohibited discrimination as to applicants or prospective applicants who are not the intended recipients of those statements. The proposed rule would also amend the standards for special purpose credit programs offered or participated in by for-profit organizations to include new standards and related restrictions. Under the proposed rule, for-profit organizations would be prohibited from using race, color, national origin, or sex as eligibility criteria, as Victoria mentioned previously. They would also be restricted in using religion, marital status, age, and income derived from a public assistance program as eligibility criteria. These are only a few of the changes proposed for Regulation B. The public comment period for this proposed rule also closes on December 15th, and we highly encourage interested parties to submit their comments. More information about both of these fair lending-related rulemakings can be found on our website at www.consumerfinance.gov. You should also refer to the Unified Agenda at www.reginfo.gov for more information about these and other rulemakings by the year. Back to you, Victoria.
Thank you. Next slide, please. So the CFPB has also taken great strides to reduce unnecessary guidance and rescinded more than 60 guidance materials by a notice of withdrawal filed in the Federal Register on May 15, 2025. CFPB has previously issued non-binding policy guidance in myriad of forms over its history. It has taken the form of guidance documents, interpretive rules, advisory opinions, and policy statements. The CFPB's current policy is to avoid issuing guidance except where necessary and where such guidance would reduce rather than increase compliance burdens. Having worked on a variety of cases here and seen the history of how investigations originate and proceed towards lawsuits, we've observed multiple times that CFPB would refer to guidance of even other agencies, its own supervisory highlights, stray statements on its website in amicus briefs, and use that to impose severe burdens on companies when they really had no notice whatsoever. And that was just another way to circumvent the notice and comment process for regulation. So this administration's policy, consistently with executive orders, is to terminate all of those non-binding policy guidance, not to rely on it in enforcement or initiation of lawsuits. And the full list of rescinded guidance is available in the Federal Register website, www.federalregister.gov. You may take down the slides, please. So now we will spend some time hearing from our Consumer Advisory Board. We greatly value your input, and we have a few questions we'd love to get your feedback on. For instance, how can the CFPB and external parties work better together?
Well, I'll go ahead and start. Again, my name is Kashana Hill, and I'm with the Redress Movement. I would just start by saying that the work that I do certainly does not provide any evidence along the lines of what we heard in terms of testimony, and it's not what I see on the ground as a longtime fair housing and fair lending practitioner and attorney, having litigated these cases in states across the country. I'll also say that what we are seeing, though, in communities across the country is deep concern around the continued gutting of civil rights protections, including the disparate impact principle and special purpose credit programs. And so to the question of how can groups and external partners best work with CFPB, I would encourage the CFPB to make policies that are rooted in history and in fact. At the redress movement, the work that we do is rooted in history and facts. It's not rooted in feelings. And the fact is that for 4 decades, the FHA's own underwriting manual was very clear that lenders must protect against, quote, the infiltration of inharmonious racial or nationality groups and rely on racially restrictive covenants that restricted the ownership of property to only people of the, quote, white race. That is well-documented government-sponsored segregation and discrimination that harmed millions of Americans of color who are still alive today, as well as their descendants. When people do such obvious harm to others and communities, basic tenets of fairness and honor would suggest that they don't just acknowledge that harm, but also make an effort to repair it. Special purpose credit programs were one of the only attempts our federal government has ever made to repair the injuries inflicted by discriminatory housing policy. And the guidance was only put in place to make the promise behind special purpose credit programs real within the last 5 years. Gutting that guidance now is an embarrassing betrayal of the purpose of ECOA and a reflection of the overwhelming deficiency of fairness and honor and truth that is currently on display. I would also add that concerns about the elimination of disparate impact liability is rooted in very recent history. Gulf South communities just observed this year the 20th anniversary of Hurricane Katrina and the federal levee failures and widespread flooding and devastation that followed. In the aftermath of that event, most people opened up their homes in communities across the Gulf South and found ways to help strangers and neighbors. However, in St. Bernard Parish, a New Orleans suburban community, folks there did the opposite. Their local government rolled up the welcome mat and slammed the door to new folks entering that community by passing a parish-wide ordinance that banned property owners from renting to anyone who wasn't related to them by blood. While that ordinance did not explicitly mention race, we can all agree that most people are related by blood to people who are of their same race. At the time the ordinance was passed in St. Bernard Parish, property owners in that parish were overwhelmingly white. Over 90% of property owners were white at the time, which effectively meant that folks of color were not able to access rental housing in St. Bernard Parish. A federal lawsuit eventually forced the parish into repealing that law and allowing more rental housing that would be equitably available to all. But it does give us a glimpse into a world without disparate impact liability. The proposed rule that we've heard about today would allow lenders to go right back to the days of redlining neighborhood. It is also out of step with the Supreme Court's rulings, and like so many other actions of this administration, it will make the country more unaffordable and less fair for working class people and people of color. I'll turn things over to my colleagues on the CAB for their perspective. Thank you.
I can jump in. Hi, my name is Chelsea Evans-Enos. I represent Hawaiian Community Assets. We are Hawaii's largest HUD-certified housing counseling agency. From a HUD-certified counseling perspective, partnership only works when the financial system is centered on the people it exists to serve. Nearly half of Hawaii households are ALIS or below, meaning they're one paycheck away from possibly being houseless. And nationally, about 1 in 5 low-income adults are unbanked, compared to about 1% of higher-income adults. When families are living this close to crisis, losing access to bank account isn't a minor inconvenience, it can disable their entire financial lives. We also know debanking is far more volatile than most people realize. In just the last 3 years, thousands of consumers had filed complaints about improper account closures, and historically, banks have closed tens of millions of accounts during periods of economic stress. The burden of these closures fall heaviest on low-income working families. The same people already struggling to stay housed, keep utilities on, and maintain credit. We saw in 2008 a housing crash. And what happens when financial institutions face too little accountability? Families absorb the damage while institutions move forward largely protected. We cannot allow the same dynamic to shape the conversation around debanking today. When a bank freezes or closes an account without valid cause or fails to protect the consumer from fraud, the family absorbs 100% of the consequences: missed rent, shut-off notices, damaged credit scores, and higher interest rate for years to come. If families face those consequences, then banks must face proportionate accountability when their decisions or systems cause that harm. The good news is that a solution already exists. Consumers need a clear right to dispute a wrongful freeze or closure with a standard process and firm timeline. The Electronic Funds Transfer Act already provides a model. It requires banks to investigate certain errors within 10 days with clear, familiar procedures that banks use every day. A wrongful account freeze or closure is an error, and it should be treated as one. Consumers should have the right to dispute it, receive a timely investigation, and have the error promptly corrected when the closure wasn't legitimate. Accountability also has to reach beyond banks to the broader lending ecosystem we're talking about today. We've heard narratives that some lenders did nothing wrong or were targeted for political reasons, but public records tell a different story. In Cordova's case, there were how many complaints? 50 complaints filed against Cordova alone, including cases where a consumer financed a $770 purchase and ended up with more than $1,800 in total costs because the lease terms were unclear. On the Better Business Bureau site, consumers repeatedly describe what they call themselves a bait and switch practices, including one customer who financed a $373 item, ultimately paid more than $1,100, facing additional fees, even after payoff attempts. The same is true of Townstone. Today, we've heard the line that no one felt discriminated against. But ECOA does not require someone to complain for discrimination to exist. Regulation B makes it clear that discouraging members of a protected class from applying is unlawful on its own. In public court filings, Townstone's own data show that about 1.4% of its applications came from Black borrowers and less than 1% from majority Black neighborhoods. In a Chicago market where Black communities make up a significant share of the population. At the same time, company executives use their radio show and podcasts to describe predominantly Black neighborhoods as crime-ridden, hoodlum weekend, and even the jungle. Those facts form the basis of CFPB's 2020 complaint and the 2024 settlement. And when new leadership tried to vacate that settlement in 2025, a federal judge refused, warning that undoing it would erode public confidence in the finality of judgments. So what does real partnership look like in this context? It means that the CFPB being clear that its primary partners are the public and the communities most at risk, and that any institution, bank, fintech, CDFI, or mortgage lender that wants to be seen as a partner must be willing to operate under transparent, enforceable standards. HUD certifying counseling agencies and CDFIs are already held to strict federal requirements. We welcome guardrails because we see the harm when protections are removed. If we want genuine collaboration between CFPB, lenders, and community organizations, the system must ensure that families do not bear all the risk, while institutions bear none. Balanced accountability, applied consistently, not selectively, is how we protect the integrity of the financial system and the stability of the households that we rely on. I will pass it on to my colleague. Thank you.
Good afternoon. My name is Thomas Fitzpatrick. I'm here in Richmond, Virginia, and appreciate both the comments that my colleagues on the CAB said, both Kashana and Chelsea. I do wonder why former CAB members are also not present on this call today. Some of them were asked to not engage with the CAB any longer. And so to answer the question of how do you partner with folks that are advocating for consumers, it would be to have their voices present at a meeting like this. I think it's telling that it's the industry folks that are sitting at the table in Washington, D.C., but not the CAB members that were invited, and I could have easily driven up 95 and joined you all today. With regards to the proposed rules, similar to Chelsea's organization, we are a HUD certified housing counseling agency. We're also a fair housing and fair lending organization. And so we see this from different perspectives. I was shocked when I saw the new rule. I wasn't shocked when I saw the proposed rule. But what did catch my attention was a statement starting at page 51 that talked about the limited public data.
Excuse me,
available.
Thomas. Thomas,
Yeah.
I'm so sorry. Your sound is coming out a little broken. Just wanted to see if there's a way you can fix it.
Okay. If I speak a little closer like this, it's supposed to be better. No.
Unfortunately, no, I'm sorry. Do you have maybe you can go off camera and see if that'll help with the audio?
Let me check. All right, is this better? No.
No. Do you have a headset you could grab?
I'm going to change computers real quick. Sorry, I'm just going to find on my phone. That's okay.
Sure. If it's okay, while Thomas is getting better audio, would you like to move to the next question and we can jump back to him?
That's okay with me. Yes.
Victoria, if you would like to go to the next question while we wait for Thomas to come in.
Sure, I just wanted to make a quick comment. One, I very much appreciate your input and the fact that you have read the materials, studied them, prepared. We appreciate your feedback. This administration is committed to rooting out intentional discrimination, and that's what we believe our work has been undertaken. I also am glad to hear that you agree that debanking is a high priority. We've been working with the DOJ and other agencies on that, and we have quite a few of CFPB's resources committed to that. And finally, I fully agree that we need transparent, enforceable standards and not selective prosecution. And that's what we have been trying to do here to ensure that the regulated entities know what is expected of them. And I refer back again to us taking down non-binding guidance, which was anything but transparent, and yet on occasion was enforceable. I will turn back to Thomas. Please, I hope we're able to hear from you.
Yes, can you hear me now?
Yes, much better. Thank you.
Awesome, wonderful, thank you. I appreciate the opportunity to speak today. I will start from the beginning to say that to answer the question of better partnerships, I do think it's telling that several of our partners on the CAB were invited to leave the CAB, and so that their voices are not present today. I also think it's telling that it was industry folks that were invited to Washington, D.C. to speak in the conference room, and the CAB members were part of that same invitation, although I could have easily driven up 95 and joined you all today. Like Chelsea's organization, we are a HUD certified housing counseling agency. And like Kashana, we have worked on fair housing and fair lending work for a number of years. And so we see this from very different perspectives. And so I would say that I was shocked when I saw the new proposed rule, but I wasn't shocked But what did shock me was a admission on page 51 of the proposed rules that talked about the limited data that was available before making this rule. And so with such limited data, the Bureau still went forth with a rule that significantly changes the industry. And so I guess my question is, does CFPB believe that qualitative considerations, general economic principles, and limited data and estimates are sufficient to undertake such complete rewriting of our fair housing and fair lending laws in this country? Or are we working just on gut and intuition? And if so, is that really the way we are going to make new rules that change what has worked for so long in this country? I further believe that the proposed rule just gets the law wrong. I read through it. I understand the nuances of looking at legislative history versus the other ways that disparate impact has been looked at by the Supreme Court and others. And yet I think ECOA is fairly straightforward in why Congress intended for disparate impact to be included under ECOA. I'm sorry, I'm changing my computer here real quick because I had to move around a little bit here. I was also taken aback by the presentation this morning, and I went back and looked through the court case referenced by the first speaker about how it was only 16 minutes of bad words that was the basis for the case. And I understand the narrowing of this discouragement rule. And so I've been trying to think through some hypotheticals of what would be inappropriate for a mortgage lender to say or not to say. Honestly, I was a little embarrassed as I came up with them, but I took some of the vernacular that's being used in current day political circles to think through some of this. And I was wondering, because the way that the discouragement rule works, and the three hypotheticals provided in the proposed rule talk about whether a creditor would not or should not know that what they're saying would be a cause of a reasonable person to believe that they would be denied or would get less favorable terms of credit. But what if that radio host that happens to also own a mortgage company talked about people of Somali descent and not wanting to provide or thinking differently about them, or talks about certain neighborhoods and calls them, and pardon my word here, but shithole neighborhoods? What is the impact that had on individuals that would want to go to such a company, or would they be discouraged from doing so? I worry that when we think only about geography and not about the individual other characteristics, what we do is bring back redlining. And we've seen the impact that redlining has had on these communities. Kashana saw it firsthand when she was in New Orleans. I see it firsthand in Richmond and Norfolk and other cities in Virginia. And so I do think that the CFPB has to be very careful as they think through what the implications will be as they move forward with this new rule. And I'd love to see other consumers' voices heard at entities like this, and opportunities like this, besides just the three of us. Thank you.
Thank you for your comments. My understanding is the comment period for the RAG is still open. So if you haven't submitted your comments, we absolutely encourage you to do so. I would like to talk in the brief time we have remaining. What are some of the emerging fair lending issues that you are seeing on the ground?
I can go. So I did pull some data across Hawaii and the communities we serve. The central fair lending issue consumers face is that families with the least financial margin are encountering the steepest barriers to safe, affordable credit. Nearly half of Hawaii households are ALIS, like I mentioned before. 31% of adults who applied for credit in 2024 were either denied or offered less than they requested. And 43% of adults with poor credit avoided applying altogether because they expected a denial, according to the Federal Reserve. These patterns matter because when families already living paycheck to paycheck cannot access fair credit, they often turn to higher cost products that deepen financial instability. We see these three issues almost every day. Opaque loan denials with no explanation or no path forward, high cost, high risk alternatives to fill the gap, and AI-driven underwriting that produces unequal outcomes even when presented as neutral. The research is clear. A 2024 Lehigh University study found that AI models used to simulate mortgage underwriting consistently recommended denying more loans and charging higher interest rates to Black applicants than otherwise white identical applicants, even when race was removed. And the UK Financial Conduct Authority has shown that machine learning credit models frequently produce unjustified differences based on demographic proxies, such as zip codes, household structures, or income volatility, all factors affecting Native Hawaiians, rural, and multi-generational households. At the same time, banking remains unstable. According to the FDIC, 14.2% of US households, over 19 million families, are underbanked, meaning they have a bank account but still rely heavily on costly alternative financial services. This volatility means even a wrongful freeze, unexplained closure, or unresolved fraud event can push a family out of mainstream banking entirely. As we think about fair lending today and emerging issues ahead, I encourage three considerations. First, fairness must reflect real outcomes, not theoretical neutrality. Proxies, algorithms, and opaque processes produce unequal results even when no one intends them. Second, we should strengthen lenders, especially CDFIs, who can underwrite based on real household cash flow, not proxy-driven algorithms or outdated credit models. And third, and importantly, we need to be cautious about rewriting foundational civil rights protections without data. The proposed changes to ECOA and Regulation B acknowledge, like Thomas said on page 51, that the Bureau lacks information, including the number of special purpose credit programs in existence, the costs and benefits of these programs, and the realities of discrimination in the current credit marketplace. Major changes based on qualitative considerations and general economic principles risk undermining the very protections Congress intended. And Congress was clear about the intent that EQUAL was designed to address both intentional discrimination and unequal outcomes that harm protected groups, to prevent discouragement, and to allow special purpose credit programs where the data shows a clear need. These tools remain vital given the ongoing disparities we see in credit access today. Any proposal to narrow these protections should be withdrawn until the Bureau has adequate data and factual record to support such a sweeping shift. Guest comments today consistently stated, we feel or we think. Today's guest comments are propaganda and missing data. We can't run a system to protect America's people by making rules based off of people's feelings instead of data. Finally, consumers need a clear right to dispute wrong account freezes and closures using a defined timeline, like I mentioned with EFTA. Fair lending is not just about preventing overt discrimination. It is about ensuring that everyone has a fair, functional, and safe financial system, one that supports stability rather than undermining it.
And if I may, in our remaining few moments, I'll just also underscore Chelsea's points that across the country and the work that I do, again, as a longtime fair housing and fair lending attorney who's practiced in multiple states, one of the things that we see going on, remaining a problem across the country, is lack of access to mainstream banking and financial tools for people of color, and particularly for people who live in majority or historically African-American neighborhoods. I'll also continue to lift up that we continue to see higher denial rates for mortgage loans for African-Americans and for people of color than for white Americans. We continue to see people of color being pushed into more expensive loan products, even when we control and account for income. So high income African-Americans are denied mortgage rates or denied mortgage loans at rates much higher than our high income white folks. We also continue to see higher denial rates and more stringent requirements placed on people with disabilities who are seeking loans, as well as people who are pregnant, who are seeking loans. And so the facts do not play out to show in any way that white folks or people with certain political affiliations don't have access to banking products or to mortgage loans. And it is very important, right, that we are very clear and that we not take positions at the CFPB, not take positions that are not aligned with facts. It doesn't logically make sense that the laws and the systems that were set up to exclude people of color and to benefit the majority white population of this country would now be used, right, to discriminate against the majority who actually set up these systems. And so our work does not show that what we've heard today is actually happening. And instead, we know that lower income folks and people of color don't have the same amount of access to mortgage loans and banking products and services than do other folks in this country.
You know, I wish this was an emerging issue. It's not an emerging issue, but the access to credit, folks that are credit invisible, have such racial disparities that it's hard to ignore. Your predecessors at the CFPB put out wonderful research and data to explain how there are folks that don't have access to credit, and the racial disparities that are very inherent in the way our credit system is set up. And so, I guess what I'd say is an emerging issue is that we're seeing that disparity from our anecdotal data growing more. We have clients that come in that are not mortgage ready because of their credit scores, and yet they have everything else lined up fantastically. And so I would urge the CFPB to think differently about how to ensure that they also have the same opportunities that others have.
Thank you very much. We really appreciate your input and having this robust conversation today. To conclude, under this administration, the CFPB is fully committed to carrying out its statutory mandates, including its fair lending, and we look forward to engaging with the board and other stakeholders about our fair lending work. Thank you again for your partnership. Thank you for your participation. And I believe this meeting is adjourned. Kim?
Yes, thank you, Victoria. Once again, thank you to our CAB members and external guests for joining us today and providing such valuable perspectives. Your insights were greatly appreciated. Thank you to the CFPB staff that participated in today's discussions, and thank you to those that attended from the public. EMT staff, we may adjourn at this time. Please disconnect.